Good afternoon. It is Saturday afternoon. It's 4 o'clock. It must be time for the senior moment. This is Connie Clark with Home Helpers. And this afternoon in the studio, I have with me Mike Wytychak.
That's
Did
correct.
I pronounce it correctly?
Wytychak, you got it right, yes.
And he is with Wytychak Elder Law in Coeur d'Alene. And Mike is, I think, a resident expert when it comes to issues involving seniors and those kind of legal documents that you really should have in place as you approach your golden years. I'll just say it that way, your golden years, as I'm approaching those golden years. So welcome, Mike.
Thank you very much for having me.
Okay, so let's start this off. Let's say, for example, my parents, let's say they're in their early 80s and they're getting up there in years, and yeah, they've got a will and they've had it forever, you know, but I see in my dad, you know, he's forgetting things and stuff. So what kind of documents should I look to see to make sure they have in place in case something happens?
Well, it falls into two general categories. One category is health-related matters, and the other category is financial-related matters.
Okay.
The health-related matters are the following: a living will, a power of attorney for health, and possibly something called a POST, which is an acronym for a physician order scope of treatment. I'll start with the living will. The living will is a document that deals with a real narrow health situation. It addresses the situation in which a person's health is declined to the point that death is imminent, death is inevitable, and machines are the only reason that they're still alive.
And they're not in that condition when they draw that up. It's prior to that condition,
right.
Correct?
While
Okay.
they're healthy, while they have their mental capacity, they address the situation on paper.
Okay.
On this document, there are three broad choices. The choices are, if I'm in that situation, then I want those machines to be continued. And the thought is, hey, I might get a second lease on life here.
It might get better.
I might get better.
Okay.
The opposite choice that people can elect is stop those machines. Let nature take its course. We'll see what happens. And, you know, from a medical point of view, the most likely outcome is fatality. There's a middle ground, so to speak, and that is stop all those machines, but give me food and or water. And the thought here, as conceived by our Idaho legislature, is people shouldn't die of starvation. People shouldn't die of dehydration. They should get those things whether they can express themselves or not. And so people can elect to have that. The other side of the coin to that thought is when death is imminent, when death is inevitable, and machines are keeping you alive, giving you food, giving you water only prolongs the inevitable and makes it worse for everybody. So there's two sides of the coin on that. But that's what a living will does. While you have your mental capacity, you express on paper what you want in that very narrow situation. And I have to emphasize that it's not something that's used when you have a heart attack. It's not something that's used when you fracture your skull. It's when there is no chance you're going to survive.
So you don't have to be afraid.
Right. You don't have to be afraid it's going to be used when you could come out of this.
Okay. Okay.
It's used when you're not going to come out of it. Two physicians put in writing, you're not coming out of this. And it's a matter of days, maybe weeks, before you finally meet your end.
So it's not a relative going, okay, let's use that living will and disconnect him because, in my opinion,
right,
kind of thing.
Yeah, it's not.
Okay.
That's not the scenario.
So they don't have to be afraid of that.
They don't have to be afraid of it, and it's often, that's often the concern, that it's
Right.
going to be used a little haphazardly.
Right.
Well, just to dwell on the living will a little bit more, you can imagine that people who are younger are going to say, hey, do everything possible, because, they've got a lot of tread on the tires still.
Mm-hmm.
Whereas people who are much older or who have health conditions that are lifelong, chronic, debilitating, and painful are going to tend to have other choices, namely, let's stop the machines and let nature take its course. So there's a pattern there that develops depending on individuals, but overall. Well, anyway, everybody should have a living will, and it's not just for seniors. It's really anybody, because we could all, unfortunately, find ourselves in that kind of situation.
And I know whenever you check into the hospital, that's one of the questions they ask. They want to know, do you have a living will, and can we get a copy of it?
Yeah, and that's because there's some federal legislation that requires them to have that. They can't force you to sign one, but they're required to ask you about it, because they want to follow your wishes. They don't want to find themselves in a situation in which they're trying to figure out, well, what do we do now?
Okay.
Doctors just want to treat patients. Doctors don't want to decide what the treatment should be in a situation in which it's terminal.
Okay.
So that's document number 1 for health. Document number 2 for health is the power of attorney for health. The power of attorney for health is a document that says if you're not capable of expressing yourself, then you appoint somebody to be your spokesperson as to healthcare decisions.
Now, I know a lot of people assume, well, I don't need to do that because I'm married, so I know my spouse would have that right. Is that true?
That is true, in that Idaho has a law called the Medical Consent Statute that says if there's a health situation, here's a list of people who can decide about your health treatment. And at the very top is a guardian. Those are court-appointed people. And then right after that is power of attorney for health. But if you don't have those things, then it goes down to spouse. So yes, it's true, spouses can consent. But many times people don't have a spouse, or their spouse is disabled, or their spouse is not going to make the decision that the individual wants, or it's a terribly difficult situation to put a spouse in sometimes, or they'll decide things that the individual doesn't want, and that could go both ways.
Right, right.
So people in a power of attorney for health name who their agent is, so to speak, and then they can name an alternate to that first choice in case the first nominee doesn't work out. And the power of attorney for health also allows them to express medical treatment that they don't want. I once had a client who had been tube fed for a period of 3 months. And she said to me, Mike, I don't ever want to go through that again for whatever reason. She said 3-4 weeks of tube feeding is all I want. So we put that in there. I've had other clients who have said, I don't want to go to a certain facility because I've been there before and I don't think highly of it. So we put that in there. So that's the second document people should have, power of attorney for health. The third is a post, which is a physician's order for scope of treatment. And that document is one that talks about whether or not an individual should be resuscitated. They've stopped breathing, their heart is stopped. They can be revived, but they may not want to be revived. And a post is that document that says whether they want to be revived or not. There are individuals who have heart disease, who have had heart attacks, and who know that the next heart attack is going to do brain damage, or the next heart attack is going to result in their brittle bones being broken and they'll wind up recovering for a year. There's reasons why people don't want to be resuscitated because of their age. They're 95. They've gone through this before. And so the patient, in conjunction with the doctor's agreement, can sign a document that directs emergency medical personnel not to revive them. The default reaction of emergency personnel, the ambulance people namely, is they're going to revive you. And the only reason why they won't revive you is if a document is in front of them saying not to, namely a post. And that post can be on the refrigerator. There can be a bracelet worn that indicates that on their wrist, or somebody can present that document to them, your neighbor or the person you're living with. So going back to your question, from the health side of things, those are the 3 documents people should have.
Let me ask you a question about the post. Okay, if I have a post that says do not resuscitate, but I'm going to go in and have some sort of minor surgery done,
Mm-hmm.
does that negate the post, and does it have to be redone after that?
A medical practice that's sharp will ask that question to the patient before the procedure is started and say, do you want to suspend your post because your heart could stop during this procedure, but that would be counter to what we're all trying to accomplish here. So you certainly can indicate that. In the absence of being asked, I think, I can't say for certain here, but I think most medical providers will assume you wanted that post suspended.
Okay.
Nowadays with people who have conditions in which their heart might stop, that's really reviewed pre-procedure because everyone realizes, hey, this is a major risk and we need to talk about the major risks so that when you consent, your consent is informed.
Okay.
Yeah.
Okay.
Good question, though.
Okay, so, and the living will and the power of attorney for healthcare, those were done in an attorney's office, and then the post is with your physician's signature. Is that correct? Or can that be done in an attorney's office also?
The post has to be completed by the physician and the patient.
Okay.
All an attorney can do is provide the form.
Okay.
And the form is written by the legislature. So you could Google.
I've seen that online.
You can get it online. The power of attorney for health and the living will similarly are written by the legislature. And you can obtain that over the internet by Googling power of attorney for health in Idaho. The benefit that attorneys can provide is to explain these things, to put it into context, to address people's concerns, because that's hard. Well, that can come from that kind of advice can come from a lot of different professionals, attorneys, social workers, medical personnel, and so people can choose. But usually these things come up in the context of people doing estate planning, people asking the question.
So it's the whole thing, it's not just that.
It's the whole thing. It's people asking the question like you did, what should mom and dad have? Or mom and dad coming in and saying, tell us what we ought to, how should we be set up legally? So a lot of times it comes up in the context of an attorney's office. But the document itself can be signed by a person. The power of attorney for health just needs to be signed and dated. It used to have to be witnessed. It used to have to be notarized, and that's no longer true.
Okay.
Yeah.
Okay.
The other half of the equation here, so to speak, is financial documents. I've just been talking about healthcare documents. When it comes to financial matters, the sorts of things that seniors ought to have, and for that matter, everyone, are the following. One, a power of attorney for financial matters.
Which is totally different than the one for healthcare.
Right. In this state, it's 2 different documents. In this state, the legislature decided that it's a separate thing. In other states, like Washington, the health and the financial matters are all rolled into one document.
Now, what if you move from one of those states to here? Do you have to change all that, or will the state of Idaho recognize those?
The state of Idaho will recognize those kinds of documents from other states as long as it doesn't violate the public policy of Idaho. And what that means, the public policy of Idaho, is there are some states that allow health matters, or financial matters for that even, that Idaho would never allow. For example, in Oregon, assisted suicide.
Okay. Okay.
If someone comes to Idaho with a power of attorney that authorizes assisted suicide, Idaho is not going to recognize that provision.
Okay, that makes
because
sense.
the Idaho legislature has looked at that and decided, no, we're not going to go there. So in general, Idaho will recognize out-of-state powers of attorney and out-of-state living wills, with that one exception. But going back to what I was saying, power of attorney for finances and a will or a trust, something to transfer people's property when they've passed away, which is what a will does and is in part what a trust does.
So all of these things that we're talking about now, the power of attorney for finances can be while the person's still living, right?
Power of attorney for finances is effective only while they're alive.
Okay.
And by law, its authority ends when the person passes away.
Okay. All right, I need to take a break, but I wanted to talk about that distinction
Sure.
because I know some people think that takes precedent even after they die or before they die, and so we need to really say which is which.
Sure,
So
we'll do.
we need to take a break, but we will be right back.
Okay, I'm good to go.
And we're back. Welcome back to the Senior Moment. This is Connie Clark with Home Helpers, and I've got Michael Wytychak with Wytychak Elder Law, and we're talking about all the different documents that seniors should have, or anyone for that matter. And the document that we just started talking about was the power of attorney for finances. And my question to him was, is this before you die or after you die? And you made the comment, this is in effect until you die.
Right. Power of attorney for finances is something that a person signs while they're alive. And like the power of attorney for health, it's an individual's authorization of who can make decisions about financial matters when they can't make a decision themselves, either because of physical problem or they're not available, they're out of the country and something needs to be taken care of. So the power of attorney is like ice cream. It has lots of different flavors and shapes and sizes. Essentially, a power of attorney means a delegation of authority, an authorization to give someone else some sort of power. A durable power of attorney means that even if the individual becomes mentally incompetent, their delegation of authority continues to be effective. And without language to that effect, Idaho law is that the power of attorney becomes ineffective. So my document has to say, I authorize Connie Clark to make financial decisions for me, even if I become mentally incapacitated. And if it doesn't say that, Connie, you can't make decisions for me if I suddenly have a stroke. So the durable is a feature that everybody wants because that's when the document really has value.
Okay, and when you authorize, because I know there's lots of fears out there about these kinds of things, when you authorize someone durable power of attorney for finances, do they have to account to anyone for what they do with your money?
They have that legal responsibility, and they have a lot of responsibilities. Keeping records is one responsibility. Acting in a business-like manner, acting in someone's best interest, avoiding commingling funds, avoiding self-serving sorts of things are all legal requirements of the person who gets this authority.
Do they have to provide reports or anything like that, or if it's just in case they're audited, they have to?
It's in case they're audited.
Okay.
They don't have to provide reports unless the document says that. And generally the document, the power of attorney, doesn't say that.
So unless someone challenges the spending, then if someone has durable power of attorney for finances, no one really looks at where the money's going.
That's right.
Okay.
So on one hand, it's very informal, and 95% of the time that works just fine.
Usually it's like a spouse or something like that.
It's a spouse, and if not a spouse, a child. But it is also the prime source of financial exploitation of seniors.
That's what I was thinking.
Because it's so easy to go to the bank with this power of attorney and take the senior's money. Or it's so easy to cash a check, that sort of thing. So the prime source of financial exploitation of seniors is family members who get their name on an account or get a power of attorney. But going back to these features of powers of attorney can be immediate or springing. And what that means is, immediate means as soon as an individual signs the document, the other person is empowered to start managing. Springing means there's language in the document that says the power becomes effective upon a certain event. And the certain event is typically when the individual no longer can make responsible decisions about their property. And usually that is evidenced by a doctor's statement.
Okay.
Yeah. Another feature of powers of attorney is that they can be limited or broad. Limited means the power of attorney authorizes someone else to do just some specific things, like cash my checks or pay my utility bills. The power of attorney that's broad means that the individual who gets this authority can have all of the power that the individual had. Manage my money, manage my real estate, deal with my bills, take care of everything. And typically that's what most people want. Because when they become incapacitated, they want everything taken care of, not just a few things. So powers of attorney are something everyone should have, and especially seniors. The other area that I want to go to is something that transfers people's property when they pass away. And there's a lot of different ways that can be accomplished. Wills are one way. They are the broadest way to address that issue. And a will is a statement to the effect of who a person's immediate family is and who should be in charge of taking care of property when someone passes away, and finally, who should receive property. And the Idaho Code has specific requirements as to what the format of the will needs to be. And it even has some laws about who should get what. But it's really quite broad. There's no law that says you have to give money to your children. There's no law that says how you divide property up among people. And this is where an attorney is really helpful in educating people about what they can do. Because some individuals are wrestling with, how do I provide for my disabled child? Or how do I provide for my disabled spouse? Or how do I deal with the possibility that my child will die before me? Or this charity may not be in existence when I pass away. Those sorts of things. But a will is just one way. There are several other ways. The other ways are beneficiary designations. A beneficiary designation means that there's some financial investment that a person has in which he or she can indicate who should get these funds when that person dies. And the most common example is life insurance. Whether you have a will or not, if you designate somebody as a beneficiary, they're going to get that money as long as they go through all the hoops that the life insurance company wants. You can do the same thing with CDs in money markets. That's been around for a long time. But you can also do beneficiary designations with savings accounts, checking accounts, stock accounts. And that can be a considerable amount of money. So beneficiary designations is another way. The third broad
and
way,
those don't have to go through probate.
those don't
correct?
go through probate. Yeah, let me talk about probate, because the fear people have is that if they have a will, they're going to cause a probate. So probate is a court case to make what the will says happen. Or if there is no will, to distribute people's property. And probate results in a person's will being reviewed by a judge to make sure it is valid, and making sure that a person's bills are paid, and then the resulting property is distributed according to the terms of the will, and it's accounted for on paper. Or if there is no will, then the property is distributed according to Idaho's laws as to who should receive property. And some people think, well, that's fine. What's the problem with that? Other people think, well, that's terrible, because I don't want a court looking at all this stuff. I don't want all these papers, and I don't want the expense. I don't want lawyers involved. Probates typically take anywhere from 3 to 6 months at a minimum. They typically cost around $1,000 to $3,000. And for some people, they say that's no big deal. Other people say that is a big deal.
Well, and two, I know that if you have property in multiple states, you
Yeah.
have to go through probate in each one of those states.
Right. Yeah. Yeah. And so people are looking for ways to avoid probate. What's not known is that if a person dies with less than $100,000 in the state of Idaho, and if there's no real estate involved, Idaho has a law that says you don't have to go through court.
Do you still have to submit the will to the court?
No. What happens is that your heirs submit an affidavit that they present to the bank or to the stock company or to whoever's holding the property, saying less than $100,000, no real estate, I'm an heir. And Idaho's law is that the person holding that property can turn it over to that individual without risk of being liable.
So when you're talking property and you said no real estate, you're talking vehicles, those types of things.
Real estate, I mean land.
Oh, okay.
And things bolted permanently to land.
So if you had an RV or something
Right.
like that,
Right.
but as long as it wasn't something that was bolted to the ground,
Right.
then you don't have to go through all
Right.
that.
I could
Okay.
have $75,000 in the bank. I could have a car worth $20,000, and I could have a checking account of $3,000. I could die with a will, and probate wouldn't be necessary.
Okay. Okay.
Yeah. So having said what wills are and what probates are and ways to avoid probate, a trust is another way of dealing with transferring property at death. And a trust is very similar to a will in that there's a document that states who's in charge and who's going to receive property. But that's just the first part of a trust. The second part of the trust is that this trust becomes funded. The signing of the document creates a legal entity, and that entity then gets funded so that it owns things. It owns a person's home by a deed being signed from the individual to the individual's trust. the trust becomes the owner of a bank account by the individual going to the bank and saying to the bank, I want you to retitle this account from my name into my trust name.
Is that what's called a living trust? Is that what those are called?
Yeah.
Okay.
A living trust is a kind of trust that says, while I'm alive, all of this money is to be used for my benefit and my spouse's benefit. And I can change it if I want. Those are the essential ingredients of a living trust.
And I remember looking something up because my sister-in-law was going through this issue. She was afraid that if she put her property into a living trust, she wouldn't be able to get her property tax discount for being a senior and for being a widow and all of that. And she would still get that, correct?
Correct. That's a
Okay.
good concern to have, because when you're changing legal ownership from an individual to another legal entity, a trust, and before you do that, you want to look before you leap. Is this going to change some benefits that I'm getting, reduction in taxes or a subsidy like agricultural subsidies? 9 times out of 10, those benefits are available to individuals with trusts, as long as the trust meets certain requirements, and those requirements are typically that it's a living trust
So you
or a
wouldn't
living
have to
trust.
worry about losing some of those deductions and benefits and stuff.
You should be concerned, but you don't have to worry, because chances are you'll be able to maintain
Okay.
the status quo.
Okay.
So the trust becomes funded. And the trust is kind of like a business, kind of like a corporation, in which there's somebody in charge and there's marching orders. And so the trust avoids probate because the trust says if the maker of this trust becomes disabled, there's a successor who's in charge. If the maker of this trust dies, then the successor has got instructions as to pay bills and then distribute. So it's kind of like a warehouse. The trust is like a warehouse. You know, inside there's directions, inside there's assets, and there's somebody in charge. And trusts typically say, when the maker has passed away and the spouse has passed away and the bills are paid and the assets are distributed, the trust ends.
Is there a time limit that the trust is supposed to end?
Historically, there has been a time limit, but that time limit now
I mean, if you were
not
the second person and you decide, well, I kind of like this arrangement, can I just keep a living trust and it's now my living trust? Or
you'll have to do some paperwork to
Okay.
reflect that, because the document says after you distribute, it comes to an end. And so if you want recognition as a trust, you have to amend it. So the answer to your question is trust can last a long time. And the example of trust that lasted for generations and generations, the closest legal example is what happened in Europe under kings and queens, in which their assets were part of their dynasty. And it just passed from one generation to the next. And it wasn't exactly a trust, but that's the
Same type
analogy, the
thing.
same thing. Some people think I'm going to create a trust that will last forever and do certain things. And to some extent, that is possible.
Well, I want to keep talking about this because I know trusts are not just for wealthy people.
Right.
So we need to take a break, but we will be right back.
Okay.
Yeah, I went through this whole. Okay, you ready? And we're back. Welcome back to the Senior Moment. This is Connie Clark with Home Helpers, and I have Mike Wytychak with Wytychak Elder Law, and we're talking about the different kind of documents that not just seniors, but pretty much anybody, as we're talking, should have. And the current thing we're talking about is a living trust, and we were talking about that you establish the trust with the documents, and it's like another entity, and then you fund it, you put those assets into that. And I know some people would want to have a living trust if they have property in multiple states, because when you have a trust, you don't have to go through probate.
Yeah. When people have real estate in multiple states, that's a good reason to create a trust. Even if they have real estate in one state, they can avoid probate by putting it into trust. But when you have real estate in multiple states, you're looking at the possibility of probate in multiple states when the owner dies, and that gets to be a nightmare.
You know, even if just across the border here in Washington, you'd still have to do that.
Right, because every state has the authority to make its laws as to how real estate is to be handled. And all of the states recognize trusts as a way to pass property on from owner to owner, even when one person has died.
And I know I used to have an opinion that only rich people have trusts, but that's not the case. You know,
Yeah,
everyday middle class, I mean, as long as you have property or something that you need to pass along and you don't want to go through probate and it's more than $100,000 and it's bolted down to land,
yeah.
then you may want to consider doing
There's
that.
several reasons to have trusts. Inheritance tax used to be a big reason, and that actually is becoming a big reason again because of changes in tax laws come this January. But other reasons were to avoid probate. Another reason was to keep your finances private, because with wills and probates, that's in the courthouse records.
So that's public record for anybody.
Public record for everybody. So keeping things private is a reason. Another reason, and this gets to disability, is that trusts are very good at controlling the management of property well after someone has passed away. Wills are good for transferring property outright when someone passes away. But that's not always appropriate, because there could be a surviving spouse who physically is not capable of handling property that's devised to him or her. Or there is a surviving child, either a minor or an adult, who suffers from a physical or mental handicap, who is not mature, is not capable of managing property that is passed on to him or her. Or there are just some people who have rotten judgment and they'll just drink away their inheritance, or they'll, you know, do things that the decedent would roll over in the grave. So a trust is a way to put that property into the hands of a legal entity that's run by a trustee who has instructions as to how to dole out this property. To the alcoholic child, he or she is to get $50 a month from this trust so long as he or she attends Alcohol Anonymous sessions. I mean, that can be written into the trust, a very clear standard as to receiving the benefits.
Okay, and let me ask you a question, because I asked you this same question when we were talking about power of attorney for finances, in that they don't really have to report what they're doing with those finances, the person who is paying the bills or whatever. If someone is a trustee of a trust, do they have to report what they're doing with that money when they're doling it out to the child or to the spouse?
Very often the trust document will explicitly address that.
Okay.
But even if it doesn't, Idaho has laws that make a requirement that the trustee be able to account, that the trustee keep records, and that the trustee acts in a responsible way, in a business-like way, acts in the interest of the beneficiary. So the standard is a little bit higher for a trustee than someone with a power of attorney, and those laws are used more frequently because trusts are more formal. Historically, banks have been trustees. Nowadays, you don't have to have a bank to have a trustee, whereas powers of attorney have always been informal sorts of things.
Okay.
Give it to your spouse, give it to a child, an adult child.
Okay.
So nowadays, for seniors, trusts can there has developed something called special needs trust, which seniors have heard about, and it's kind of a vague concept for them. So I want to kind of hit that.
Okay.
a special needs trust, in a nutshell, is a kind of trust in which the recipient is able to maintain their eligibility for public benefits and get some benefit out of a trust. Here's what that means. By public benefits, in particular, I'm thinking about Medicaid. Medicaid is the federal and state program that pays for nursing homes and pays for assisted living facilities. And those programs require that financially a person have little assets and they have little income, and the taxpayer dollar is the last resort. Well, someone who has assets can say, gosh, I don't want to upset that apple cart with that Medicaid, but at the same time, I want to do something for my surviving spouse or my disabled child who suffers from something that's going to keep him or her in an institution for the entire lifetime. But if I do an outright inheritance, that'll ruin their eligibility, and
it'll knock them off Medicaid.
And it'll be short-lived. It'll cause more problems than it solves, because their lives will be upset, and they'll have to reapply, and they won't know how to do that, and it's just a mess. But on the other hand, they don't want to disinherit their spouse who's in the nursing home. They don't want to disinherit their child, and so a special needs trust has limitations written into it, such that the beneficiary gets something out of the trust without ruining their eligibility.
So they might get a monthly stipend or something like
that.
They
could get a monthly stipend, or they could get payment for things that Medicaid doesn't otherwise cover. For example, Medicaid covers one pair of eyeglasses over a period of time. I think maybe it's a year. Well, it's not hard to break a pair of eyeglasses in the course of a year, and a special needs trust could pay for that. A special needs trust could pay for transporting a beneficiary to church or to a recreation event like a family reunion, and that's not something that Medicaid would ever pay for. So it provides some bells and whistles to enhance a person's life, but yet not take away the core benefit that is paying for their health care. So that's what a special needs trust does. And with seniors acquiring more assets as the years go by, houses that are more valuable and investments that hopefully are growing now that we're past the worst of the recession, they have more to pass on, as opposed to when I started 30 years ago, when they had very little to pass on.
So we talk some in here about dementia and the prominence of Alzheimer's. And so if you've got a couple where the one spouse is having symptoms and signs of that, and you see that person deteriorating, you would think in your mind, oh, well, I'm going to outlive them. But then what if I don't? So this would be one of those what if I don't kind of things that you would set up to make sure that if something happens to you first, being the caregiver, that you make sure that your spouse is taken care of if something should happen to you.
Yes, and the demographics are that typically women outlive men. Typically caregivers easily precede the ill one that they're taking care of because they burn out. And so a special needs trust is a way that they can carry on this benefit that they've been providing even when they're no longer alive.
It's like a just-in-case kind of thing.
Yeah, right.
You hope you don't need it, but, if you're driving down the road and you get into an accident, what's going to happen to your spouse?
And the trust has written into it that if the person passes away, who's the beneficiary, the spouse or disabled child, well, whatever money is left in this trust goes to so-and-so. So it's not as though the money is simply lost. It passes on to the other folks who will enjoy something out of it and are not suffering from a disability.
So it would be a way to make sure either a disabled child or a spouse who may have a disability, is taken care of in case something happens to you. And I think that's interesting because I was talking about this, I guess, about a year or so ago, and all of a sudden the light bulb came on because I knew I'd heard about special needs trusts for children. But all of a sudden the light bulb came on. Well, what about if your spouse now has dementia and Alzheimer's and you've been going through all these bells and whistles to get them on Medicaid because they're in a nursing facility or something like that? You don't want something to happen to that if something happens to you.
Sure, because that disabled spouse has adjusted finally to the assisted living facility or adjusted finally to the nursing home. And yeah, you change the status quo, it's not only upsetting, it threatens their health.
So if you are getting older, there's a number of things you really should sit down and decide and get worked out. And even before you get older, I mean, you know, things happen to people. Now, so far as a will is concerned, as an example, me, we have our will, but the person we have that's the executor of our will is now several thousand miles away. If you move to a new location, should you redo your will and make sure that the executor is someone close by, or is it a bad thing to have the executor on the other side of the country?
Yeah, well, there's two things to think about if you move. First, as you pointed out, there's this geographic distance, which can or cannot be a hindrance. Nowadays, with telephones and cell phones and faxes and email and transmitting files over the internet, it is not such a burden to get paperwork done. On the other hand, people select individuals because they can come and have a hands-on grasp of how things are to be done, and if you move, that's not the case anymore. So it can cut both ways. What I tell people is the person that you choose for your power of attorney, the person that you choose in your will or whatever document, the person that you choose ought to have the skills that are necessary to do the job, ought to have the willingness to do this sort of thing, and ought to agree to it in advance. Because if those three things aren't present, you can't be sure that this is really going to work out.
All right, and let me ask you another question. You've got your will made out and everything, and the person that you had as your executor passes away. What happens to your will? Is it null and void, or?
The will isn't null and void. Many times wills will name an alternate to your first choice. And if it doesn't, the state of Idaho has laws that address the priority of people who would be appointed for that job. And in a nutshell, that priority list is spouses, children, and then relatives.
Okay. So it would default to whatever the state lists as the priority of who would be the executor.
Yes.
Okay.
Yeah. Now, going back to your question, if you move away and your personal representative or your executor, those words are synonymous, no longer is nearby, and I answered that. Another consideration is, does the will say things that are no longer appropriate? If you've moved from California to Idaho, your California will may talk about California law as governing how things are to be understood. Well, that was fine when you lived in California, but you're here in God's country now. And so it's not helpful for an Idaho attorney to try to look up California law, nor is there much point to it. So the will can become outdated because of that. And that's another thing to look at. Does the will say things that are no longer appropriate?
Very good, very good. Well, if someone had questions or wanted to, ask you some things pertaining to this, how would they get in contact with you?
Well, I'm listed in the telephone book. I'm the last name under W, I believe. Wytychak, Wytychak. And our office has a staff of 4, and any one of us can address these questions. We also have a website, Wytychak Elder Law, in which people can email us through that if they wish. So those are the easiest ways.
Well, thank you, Mike. I appreciate you being on here. You're always a wealth of information. I know whenever I have a question, you're always there to answer it. So thank you.
You're welcome. Thanks for asking me. I enjoy speaking publicly about these sorts of things. So thanks.
Well, you can tell. You can tell just by the way you explain things very easily. And I'd like to thank you all again for listening. And I want to tell you about something that's coming up. November is American Diabetes Month. And so the Panhandle Health District is having a Diabetes in You 2012. It's going to have vendors. They're going to be doing your blood sugar testing. They're going to talk about diabetes and the secret attack on your teeth, taking control. They've got a cooking class. They've got all kinds of neat things going on. And this is going to be on September 17th from 8 in the morning until 1 in the afternoon over at the Panhandle Health District at 8500 North Atlas. So if you've got diabetes, you know of someone with diabetes, or you think you might just want some more information, head on over there that Saturday, and they can help you out. Again, thank you for listening to the Senior Moment. This has been Connie Clark with Home Helpers, and you have a wonderful rest of your afternoon. Good day.